Called into the boss's office. Sometimes it can be an unpleasant experience. Uncomfortable questions. Do you answer? Are your actions being investigated? Maybe you're getting written up. Are you entitled to representation? Hi, I'm Terry Cox, Communications Director for the California Statewide Law Enforcement Association, and with me is Legal Counsel Erin Eckelman. Erin, you're one of 6 attorneys here at CSLEA. You get a lot of questions from our members. A lot of those questions are the same, and sometimes they have to do with, when am I entitled to representation?
Right. Oftentimes, members don't know when they're entitled to representation. It arises when you are called into your supervisor's office, they start asking you some questions, and those responses could lead to discipline. Now, our membership is made up of peace officers, firefighters, and non-sworn members. Their right arises under a different either government code section or case law. If you're a non-sworn member, your right to representation is referred to as your Weingarten rights, which arises from a Supreme Court case. For public safety officers, their right arises from the Public Safety Procedural Bill of Rights, or for firefighters, the Firefighter Procedural Bill of Rights.
It would be nice to have somebody on your side, at your side, and that's what representation is all about. But you're only entitled to it under certain circumstances.
If you have a reasonable belief that your responses to the questions being asked could be used against you in a disciplinary action or punitive action, then you do have a right to request representation. Punitive action is referred to in the government code section and defined as any action that could lead to dismissal, demotion, reduction in salary, or written reprimand, or even transfer for purposes of punishment.
So what do you do if you think continuing a discussion with your supervisor will lead to disciplinary action?
What we recommend our members to do is if they're in a meeting and they believe that they have a reasonable belief that responding to any question could lead to discipline, we recommend that they ask their supervisor, could a response lead to discipline? Am I going to be disciplined for this? At that point, the supervisor responds yes. We then recommend that the employee request a representative. And at that point, the meeting should come to a stop. The supervisor should allow that employee to contact CSLEA. They can contact their assigned representative. You know, there's 6 attorneys here at CSLEA, 3 up north, 3 down south, and all of us are there for our members so that we can assist them in any type of interrogation or interview where their responses could lead to discipline.
What if it's not an interrogation and it's just a meeting with your boss, but you know it's uncomfortable and you don't want to be in there alone? Does that give you right to representation?
You know, if you ask the question and your supervisor says, no, this isn't going to lead to discipline, you are not going to get in trouble for this. For peace officers, if it's not going to lead to punitive action and it's merely just a informal, maybe it's to go over your performance, to discuss something that had happened, you are not entitled to representation. It's only if your responses are going to be used against you in discipline, punitive action, or something is going to be, your supervisor intends to take action against you.
But certainly if there's any concern, our members can give you a call and get some guidance or ask you, can you be there with me? Why can't you be there with me? How should I handle this?
Absolutely. Often that happens. We'll get on the phone, we'll talk to the supervisor. Our attorneys are here for our members. We'll make sure that it's not a situation which their rights are being violated.
So Erin, what happens after an employee does request representation?
Well, if the employee requests representation and the supervisor acknowledges that the questions being asked could lead to discipline, that employee should stop the interview or meeting and immediately call CSLEA. One of the 6 attorneys will respond if you're in Northern California or Southern California. And at that point, CSLEA will attempt to get there, or we will try to reschedule the meeting. The employee should be given a reasonable amount of time to meet with the CSLEA representative to discuss what's going on, and then the meeting should then proceed.
And is this the same for our sworn and non-sworn members?
Well, for our sworn members, they do have POBAR rights, which if they are going to be interrogated, they should be given proper notice, written notice with the time, the date, the location, who is going to be conducting the interrogation, and the subject matter of that interrogation.
What's the danger of not having your representative with you?
It's your right to have the representative. By not having the representative with you, oftentimes a supervisor may coerce you into responding a certain way. You may feel pressure to respond to a question that maybe you don't have to respond to because unless you are what we refer to as being given a Leihbarger, you are not being compelled to speak. So unless you're compelled to speak, you're really giving a voluntary statement. If the employee has a reasonable belief that responding to the question is going to lead to discipline, then that employee, it's their responsibility to request a representative, because the employer is not responsible for telling them you're entitled to a representative. It's the employee who must invoke that right. So they need to ask the question, otherwise their supervisor is not going to just say, you should go get a representative.
What if you're in that meeting with your supervisor and you have mentioned that you do want representation and your supervisor says no?
At that point, obviously, you should continue with the meeting. You're not being compelled to speak, you should respond. It's a touchy one because you don't want to be insubordinate. But at the same time, you should think about how you're responding. And later on, if those statements are used against you in a disciplinary action or to bring adverse action against you, we will raise that on appeal. In addition, we may file a PERB complaint, which is basically a denial of your right as a member of CSLEA.
Certainly, any questions, call you, correct?
That's correct. We're here, there's 6 of us, 6 attorneys statewide, and we are here for our members to answer any questions.
All right, and that's the message we want to get across. If you have any questions, any suggestions, any ideas for us, you can email us or you can call us. We have an office in Southern California, we have one in Northern California, and we look forward to hearing from you. Thank you.